Let's take a look at employee rights under the NLRA. The NLRA does not directly affect employment outcomes, but provides employees with a means of acting in their own interest to improve their terms and conditions of employment. The fundamental rights conferred by the NLRA, often termed Section 7 rights, include the right to do the following or refrain from such activity: to engage in self-organization, form, join, or assist labor organizations, bargain collectively with the employer, go on strike, and engage in concerted activity. The self-organization and concerted activity protected by the NLRA is broadly construed. Concerted or group activity is not confined to formal collective bargaining conducted by unions. Instead, any efforts by employees to join together for mutual aid or protection can qualify as protected concerted activity, even if those employees are not represented by a union or attempting to form one. What makes employee actions concerted? In general, conduct must be engaged in, with, or on the authority of other employees and not solely by and on behalf of the employee himself to be concerted. Evidence of group activity, such as discussions among employees or the delegation of an employee to speak with management, is generally necessary to demonstrate that the activity is concerted. However, for unionized employees, a complaint that relates to enforcement of rights under a labor agreement is concerted activity, even if it's raised only by an individual because it affects all employees covered in the agreement. The NLRA is also violated when an employer terminates an employee to prevent that employee from exercising her right to engage in concerted activity. To receive protection, an employee's actions must be concerted and be for the purpose of mutual aid or support. Even when it's undertaken for mutual aid or support, concerted activity by employees is not always protected. For one thing, the activity must be related to employees' concerns regarding their wages, hours, and terms and conditions of employment. Second, the manner in which the activity is carried out must not be extreme or abusive. In policy prohibiting negative conversations about coworkers or managers violated the NLRA because of the likelihood that employees would view the rule as prohibiting complaints about management decisions. Employees must not discipline or discharge employees engaging in protected activity under the guise of workplace conduct rules by declaring union organization to be harassing. However, employers still have an opportunity in such cases to assert an affirmative defense by showing that the disruptiveness of the act, and not merely its violation of the policy, was the reason for imposing discipline. Today, employee complaints about their terms and conditions of employment are as likely to be aired electronically through social media sites as they are to be voiced in person around the water cooler. But fundamentally, the issue is still whether the employees initiating such communications and any coworkers responding to them are engaging in protected concerted activity. Employers in both unionized and non-union workplaces must respect the right of employees to join in expressing concerns regarding their terms and conditions of employment.